This is a ongoing program that we've been putting on for employers, interested parties, and the public with regard to how we got here in the area of labor and employment for cities, municipalities, school districts, and public entities. Brian put on a presentation the other day in Columbia, and it was well received. So I'm going to let Brian follow his notes. And I may interrupt him every now and then, but the idea is to at least give you the same presentation that was presented the other day in Columbia, Missouri, which was well received. So Brian, all yours.
And the good news is the presentation was quite simple and short, and we had a very lengthy Q&A. So we'll focus on the Q&A, but what I want to do first is we want to give you a history of how we got here in collective bargaining with public entities. When we talk about collective bargaining today, we're talking about negotiations between employees and employers regarding wages, hours, and other terms, conditions of employment. So generally, during collective bargaining, parties will sit in a room and try to hash out a contractual agreement that addresses those terms. So when we talk about collective bargaining today, that's what we're referring to. In 1935, the National Labor Relations Act was passed as Franklin Roosevelt's New Deal plan. And the deal was to encourage and protect collective bargaining between private employers and employees. Private. FDR actually said all government employees should realize that the process of collective bargaining, as usually understood, cannot be transplanted into the public service. So back in the 1930s, the President of the United States, Democrat New Deal, said collective bargaining does not apply to public entities. And then we have this quote from George Meany, the first president of the AFL-CIO. It is impossible to bargain collectively with the government. So again, in the 1930s, we have the President of the United States and the president of a major union both saying it is impossible to collectively bargain with public entities. And we'll get to reasons why that is. First, I think both realize that it's not good practice for public employees to strike against the taxpayers. Basically hold out and say we're not going to provide public services because we're holding out for more money. So both parties realize that's not a good idea. Also, they both realize, you know what? These union members, they're paying dues to unions, and those dues that the unions use go to fund political campaigns. So essentially, taxpayers' money is going to political campaigns that they may not support. That's not a very good idea. So they realized this. A little later, in 1945, the voters in Missouri ratified Section 29 of its Constitution to state, employees shall have the right to organize and to bargain collectively through representatives of their own choosing. In 1947, the Missouri Supreme Court held that Section 29 does not apply to public employees. So someone tried to litigate the issue that the Missouri Constitution applied to public employees. The Missouri Supreme Court, coming off this New Deal, FDR's quotes, the President of the Union's quotes, said no. Constitution only applies to private employers.
And the importance of this is it's a decision at the time. The mindset is known. This is the same people who were participating in the constitutional reform in the state of Missouri, the same people who were participating in the political process at the time of the constitutional reform. And so this language that appears in the Missouri Constitution is being decided upon by the very same people in the same milieu, the same time, the same time frame as that had been written. And they decided, no, that doesn't apply to public sector because the world, at least our world at that time, said it made no sense to. But now, fast forward.
Yeah. The law, that decision was good for 60 years, but a funny thing happened. 50 years ago, a third of the workers belonged to the union. Now, it's less than 1 in 10.
In the private sector.
Yes. And so the concern was, well, how do you replace those lost dues? And the answer was, well, we need to increase public sector union memberships. So the first time in history, public sector union membership outnumbers the private sector union membership. 39% of government employees now belong to a union. And public sector benefits and pay far exceed the private sector. In fact, the Wall Street Journal said the public sector unions may be the single biggest problem for the U.S. economy and small democratic governments. In 2007, the Missouri Supreme Court found that Section 29 applies to public employees as well as private employees.
And here's what's interesting. The case went to the Missouri Supreme Court on a stipulated record. When you make a stipulated record before the court, it's limited. It's limited to what the parties both agree to on a piece of paper for purposes of what their statement of the facts are. There's no real debate. There's no real interaction. There's no real contest of the issue before the court. So the court essentially gets a clean slate upon which to write the decision. And that's precisely what the Missouri Supreme Court then did in 2007.
Yeah, and then in 2012, the Missouri Supreme Court found that public employers have the affirmative duty to bargain collectively. So from 1930s, from the President of the United States and the President of a major union saying that public bargaining should not apply to public entities, in mid-2000s, the Missouri Supreme Court said, no, we think it should. I was going to say, and a lot of people argue and believe that that's not how government should work, that legislators should legislate and courts should interpret. And if you go back to the original interpretation of what that language meant in 1945 when the Missouri ratified the Constitution, it was absolutely very clear that the voters and the government intended it not to apply, not for collective bargaining to apply to public entities. That was the intention. So, go ahead.
The sections of the statute that have talked about public employees and their rights and how they discuss issues involving terms and conditions of employment with employers is Section 105. Section 105 was clearly written. I mean, there's no doubt about it. It says the only obligation is to meet and confer. Meet and confer. And for years up until 2007, that simply meant that a municipality would say to the union, look, if you want to talk about this, we'll be glad to talk about it, but we're going to make a decision either in the city council or the board of aldermen or some elected body will finally have the final determination as to what happens. And if we have to change that later on down the road, we can do so, but we're going to obviously simply meet our obligation to meet and confer with the union. There was no mention in that statute of meeting in good faith and bargaining in good faith and bargaining and negotiations and night-long sessions and all that kind of silliness. That was never in that statute.
So what effect has this had on municipal governments and employees? And here are some practical examples that Jim and I have dealt with in our practice after the Missouri issued this decision. First thing, when a union wants to collectively bargain with a municipality, their union membership will generally submit a proposed contractual agreement that is about this thick, asking for things and items that other municipal employees would not receive. So essentially, they're starting off the relationship of, here are all the municipal employees, but we want to be the super municipal employee. We want terms and conditions that far exceed that our other people in different departments in the city receive. And our response has generally been, kind of smiling, saying there's just no possible way we're ever going to agree to any of this. But we can't say that because we have to bargain in good faith. And what bargain in good faith means that you have to sit down and talk about the issues with them and try to reach some type of mutual agreement.
And so the result is litigation now is being repeated week after week in the Missouri courts where a union says you're not bargaining in good faith. They take the employer into court. They talk about how the employer didn't seem to be willing to agree. The employer seemed reluctant to agree. The employer didn't have the dates and the times available. Most of the just take municipalities. The city managers in some of these municipalities wears about 5 different hats. They really don't have a full staff of labor relations personnel, of human resource personnel, and of all these people to do all this research on what the document should read or shouldn't read like, or what it should mean or shouldn't mean. And so these city managers don't have the time. So the unions are complaining that because the city manager isn't sitting down for 7-8 hours a day negotiating in good faith with the union, they're therefore in violation of the Missouri Supreme Court standard. Well, no city manager wants to be accused of violating the standard because obviously they're appointments, generally speaking, and they want to keep their jobs, so they do everything they can to placate the union, which ultimately means giving in to the union's demands with regard to certain issues. And then that just keeps snowballing and cascading down into worse and worse agreements for municipalities and governmental entities.
Now, here's where you as taxpayers should be concerned regarding this process, and also employees who are represented by unions. What happens is they contact us. The union has an attorney that they have to pay out of their dues. the city has to get an attorney to negotiate too. So right away we have 2 attorneys in a room that are going to negotiate who are being paid an hourly rate. That hourly rate is being paid by the taxpayers. Then you have, let's use firefighters as an example, then you have the fire chief who has to be at the collective bargaining because he's a representative. He's a management representative, so he has to be there. So now he's collectively bargaining instead of doing what he was hired to do by the taxpayers, which is fight fires. He has to negotiate. Then you have a human resource manager who's attending on behalf of the city because human resources have to be there, again, as part of management. So instead of doing her job, which is human resources, which the taxpayers pay, she's now bargaining collectively on behalf of the city. And not only that, now you have a union steward who's in attendance on behalf of the union, and some type of union leadership member who's also bargaining on behalf of the union. So you have about 6 or 7 people who are trying to reach an agreement after giving a page of this, where the city's saying there's just no way we can agree to all that, and the union goes back and forth and says, well, what about this, what about that? The last contract that I negotiated on behalf of the city took 3 years. You know why? The union is in no rush to get anything done. All right? Now, put yourself in a position of a union membership. Wouldn't it be fun to just negotiate a contract for 3 years instead of going off and doing your job? Because guess what? When they're negotiating the contract on behalf of your union members, the taxpayers are paying them for that time. That whole time they're negotiating, it's coming out of the taxpayer's pocket. So you're paying for that. So there's absolutely no rush. So they know that the city's not going to agree to a contract this big, but that doesn't mean that they can't try to negotiate for the next 3 years and get something like this. And the first day we got the proposed contract, we knew in our minds what we wanted to agree to. And, of course, we bargained in good faith. We went back and forth, but at the end of the day, it was completely inefficient and a waste of money. And there's just a better way of doing it. And unfortunately, when the Missouri Supreme Court came out with their decision in 2007, 2012, there was no system in place. There were no statutes in place to say this is how you bargain collectively in the state of Missouri because no one even thought about collective bargaining with public entities.
Those contracts that were in place were moderate, were reasonable, and were workable. And they called them memorandums of understanding, memorandums of agreement, and they did call them contracts in many places. And the Missouri Supreme Court, up until 2007, had said, well, they're binding up to the point where the city says we have to get out of them. And the city reserves that right throughout the process to unravel it if they've in fact agreed to something that isn't economical or isn't practical going forward. But those memorandums of understanding did in fact work. There were a lot of fire departments, there were a lot of police departments, there were a lot of operations out there where employees were covered by memorandums of understanding, and it worked. It was workable, it was doable. The union got their dues voluntarily from the employees, and it was no big deal. But along comes 2007, and now it's forced. Now it's mandated. Now it's everybody's duty to spend more money and waste more money.
So the main point from that is negotiations, they're costly and they're time wasting and they're not very efficient. And one of the main problems is there's few guidelines and requirements for negotiating in the public sector. And whenever there's uncertainty, it means increase in cost and increase in litigation risk. Another thing that taxpayers and employees who belong to the union should be concerned about is no one knows where their union dues go. There is absolutely no financial disclosure as to where these unions go. Unlike the private sector, in the private sector you're required to file financial disclosures. Union members are entitled to know where their money is going. Now, it's absolutely ridiculous that the private sector is more transparent when it comes to these financial disclosures than the public sector. And no one has been able to give us any type of reasonable explanation why public unions should not publicly disclose where their finances go to. In fact, they should, right? Because it is the taxpayers' money. I mean, the taxpayers are paying the salaries and those union dues are going to the unions.
The union's argument prior to 2007, at least in Missouri, was, well, we don't have to do any sort of disclosure because we're private associations. It's like joining the Moose Lodge. It's like joining the Elks. You know, it's just an association. We're just a good bunch of people. How do you like that? We're just a good bunch of people getting together from time to time and enjoying our company. Well, that changed after 2007 because now every employer who's an entity, a public entity of any kind, now has an absolute obligation to bargain in good faith, so to speak, with that union. And that's where the change occurred. But the law didn't ever catch up with itself. It was the Missouri Supreme Court giving us that obligation instead.
Another concern that taxpayers should have is the influence that unions are having now on local elections. Now, think of it this way. Wouldn't it be absolutely ridiculous if a union funded money to a mayoral candidate or Board of Alderman candidate, and that person was then in charge of determining their wages and hours in terms of conditions of employment? I mean, isn't there a conflict of interest in that? I mean, that concerns me. If a union was able to get their candidate in place, and then that candidate was able to decide how much to pay them, it seems to me that there would be lots of room for some fraud for the taxpayers. And in fact, I won't name the municipality, but we've heard stories where outgoing mayors and Board of Aldermen have made sweetheart deals with unions and increased their wages and hours in terms of employment on their way out, and then left the mess for the new board and then the new mayor. And who's left with the bill are the taxpayers. And then people ask, well, why can't they change that? Well, there's this thing that they call the evergreen clause that they put in these contracts, or forever green, all right? Evergreen clause says you cannot change the terms and conditions of this employment until the union agrees to change
Forever.
it. Forever. And so it stays in place until a new contract is reached. Now, thankfully, there is some reform right now pending in the Missouri legislature. Senate Bill 602 has been sponsored by Senator Onder, and that's pending right now. And that addresses a lot of these concerns. But right now it has been passed. We hope it is, but something has to change here. There has to be real reform because, unfortunately, the taxpayers aren't getting their say with respect to these negotiations. The other thing I would like to address that should concern taxpayers and also employees of unions, because what we like to say is this is not an anti-union speech. Senator Onder's bill, Senate Bill 602, is not an anti-union bill. It's pro-employee because what we're simply asking for is disclosure and some common sense approach to negotiations.
And the key to it is that Senate bill Senator Onder is proposing and put out there was modeled directly after the same federal requirements that labor unions have in the private sector. So every union in the state of Missouri, except, with the exception of 2 or 3, have already been doing this. And the complaint is, well, we're going to have to hire accountants. Well, you already have it. You're already doing it in the private sector. So all we're asking for is to do the same forms, fill out the same forms with the same explanations for the public sector so that people can see where the money's coming in from and where the money's going out to.
And so some of the reforms that are addressed in that bill is financial disclosures, which is good. It also addresses elections. A lot of these union employees, they inherit this union from their fathers or grandfathers. They never really got the opportunity to vote, so we simply ask, if you want your union, you can vote for it, recertify it every year, and if you don't want your union, you can decertify it. And it's through a democratic process. And it gives actually the employees an opportunity to, say for the first time during their employment, yes, I want a union, or no, I don't. And so I think most of the employees enjoy that. The other thing, too, is it addresses release time. And release time is simply, we don't think taxpayers should have to pay a union member for attending union business. So when they're negotiating a contract, that shouldn't come out of the taxpayer's pocket. That should come out of union dues because it's on union time.
And you can see how this works. The union calls up management and says, by the way, we want 4 people from this department to attend our next negotiations. And management says, well, we can't release that many. It's going to disrupt the whole department. We've got to have some workable solution. Well, if you can't give me that, then I'm going to want something else instead. And so suddenly, that's the easy thing to give away. And so now what have you done? You've subsidized the union through taxpayer dollars for purposes of their goal in collective bargaining.
And then another thing it does is it gets rid of these evergreen clauses. I think one of the common sense approaches to the bill, Senate Bill 602, is it just says, we'll negotiate your wages for a year, but after a year you got to renegotiate them. And that does make sense because actually union employees may end up earning more after a year because the market may have changed. But there's no reason why you should lock in a city and the taxpayers to a deal that financially does not make sense after 2 or 3 years, especially if a municipality has some financial difficulties during that period of time.
You've had slowdowns, you've had sick-outs, you haven't ever seen a strike yet in St. Louis County with regard to municipal employees.
Then we haven't pushed hard enough.
Well, and the problem is the city managers are afraid to push because they know their body politic behind them is oftentimes including people who say, you need to support the unions because that's how I got elected. You'd have to have some votes. And just like you saw when Zuckerberg went up to Washington recently, he had private meetings with all those same people that are going to grill him the next day, and you can just imagine how, well, we're really your friend. We're not going to ask you tough questions. You can imagine that. It's the same process with all the labor organizations. The amount of dollars that floats into every election nowadays from unions is tremendous. That's where the money doesn't go to arbitrations, negotiations, and representing employees. It goes into political efforts.
Absolutely.
Now, the one thing that may be changing that is this pending Supreme Court decision that we should see a decision on this summer with regard to the mandatory nature of participating in union dues contributions out of Illinois. That may change that faster than trying to get the A taxpayer lawsuit is going to have to focus on harm directly to that taxpayer.
Yes.
This is all indirect. This is so obfuscated. This is so blurred. By the time the tax dollars go into the city coffers, then those city coffers then spend it on wages and benefits, it becomes blurred. It would be extremely difficult for taxpayers to in any way participate in that process through litigation. Pensions have always taken two forms, defined benefit and defined contribution.
Exactly.
The defined benefit plans that have been in existence for municipalities, for their employees, have been out there for a significant period of time. Most municipalities, especially the ones that have existed before the 1960s, instituted defined benefit plans. And if you remember, a defined benefit plan says when you reach a certain age, we will give you so many dollars. And we will guarantee you receive those dollars, and then maybe an inflation component in there, a COLA component, and some other component that makes those numbers go up and go up and go up, because that's what the unions were seeking for all those years. And that was done before it became, quote, good faith bargaining after 2007. That was done under the old meet and confer, because it was an idea to be, maybe it was paternalistic, but maybe it was an effort to try and give, quote, the best benefits to employees without having the highest wages in the land. And that was the grand compromise for most employees working in the public sector, that I got good benefits, I never got laid off, I didn't make great wages, but I know I got a great pension, I know I got a great health care. And they even included continued health care beyond retirement days. So up until the time you convert to another plan of any kind, the cities and the agencies and the school districts would then have an additional component where they would be able to pay, and the school districts obviously didn't participate in Social Security, and there's all other kinds of fine-tuning in that. But the idea was under these defined benefit plans that we would have such a great pension for these employees that we wouldn't have to worry. Well, now those pensions are coming back to haunt municipalities and governmental entities because those have such underfunded liability associated with them. The government requires under not just the FASB in the private sector, but GSB rules to at least account for those. So the cities have to identify what that potential contingent liability is should there ever be a cessation of payments, a cessation of operations. And you've seen municipalities around the country declare bankruptcy because of these plans. They're so overweighted and they're unable to make payments to them.
Yeah.
They're a problem.
We actually asked the Illinois government attorney to come here to address that specific issue, but Illinois couldn't afford to send him. Illinois couldn't afford to send him over here.
It's the death of 1,000 cuts. There's the first piece where you have to bargain in good faith. Then in 2012, the Supreme Court said, well, that means even more. That means there's certain additional requirements. Now, they haven't had a chance since then to do more harm, but those are the two major pieces, 2007, 2012. We're only in 2018, so we're 6 years after the second major hit. And it's going to be some time before anybody realizes how bad this was, and you can do something about it, hopefully, We'll get some rotation within some of those positions where we'll get some decent people up there, and I know the Missouri plan's an issue, but we'll get some hopefully brighter minds who at least look at the literature and look at the real history and look at the story on it. Part of the problem also, and I don't mean to speak too long, but I just have to get this one in there. Up until 2007, the school districts, being what they are, would always sit down with their teachers and talk about their process as being good faith. Because the union would goad, the NEA especially, would goad those employers in the school districts to use that language, we're doing it in good faith. So for them, it wasn't a change. Well, so what? What happened in 2007? It really wasn't a change. The meet and confer law really stuck to its guns, so to speak, in the public sector beyond school districts. Because school districts kept using this meet and confer, not we're going to use that, we're going to use good faith. Because school districts kept using good faith as an obligation, it was self-imposing on their process what that was, which goes back to what Brian was talking about before. It just created additional work for lawyers. The lawyers who work for school districts, and we work for some, but we try and stay out of it. But the school districts then became more lawyer-heavy, so to speak, and that's what's become the problem there. Now you have that entrenched where they're used to, and they eat, sleep, and rest on that good faith standard, which is problematic.
Which reminds me of another example. One school district nearby paid a teacher to lobby on behalf of the union. So the taxpayers were paying this teacher not to teach. She didn't teach. She went to Jefferson City to lobby.
Well, we just lost that with regard to first responders, in part because the firefighters union has a lot of clout, has a lot of dollars that never get explained for. So then you have the chief of the fire chiefs, and the police chiefs even got their own statute enacted where you can't fire a police chief anymore for any reason except gross misconduct, criminality, and some other sorts of things. So they've been lobbying as independent groups to try and get more rights for themselves, which then insulates that. We did have a piece of litigation here in the county recently where some firefighters showed up and were participating in political activity, but they were using the uniforms from a different fire district. Oh, how clever. But they're still using them. And so the city terminated them, and an insurance company eventually settled on that case. But there isn't a real direct prohibition on that, similar to the Hatch Act. With this this U.S. Supreme Court case coming down with regard to union dues across the country for the public entity side of the world, coming out of Illinois, we think that'll put a big punch into that strength of unions with regard to their dollars and how they spend their dollars. But there isn't anything on the horizon for the Hatch Act. The Supreme Court case that will be decided this year goes to the issue of whether or not union dues can be mandated. Are they required? Can they be required for all public employees? And the Supreme Court, I think, should come down and say no. Interesting, one of the justices was asked the rhetorical question, does this mean the end of unions financially? And he said, well, I think it will. Oh, okay, that was the end of that discussion. But it really won't, because unions can still generate dollars through private association efforts. They still don't have a limitation on that. So what I think what the Supreme Court decision will have in terms of its impact will be more educational than anything else. It really will start the discussion among all employees in the public sector and even in the private sector as to whether or not paying union dues is something which they have to do, which I think will encourage the discussion on right to work, which will enforce the opportunity to have more of those discussions both in the workplace and elsewhere.
Also, you're not required in Missouri, if you're a public employee, you're not required to join the union. So practically speaking, even if Janice was ruled in our favor, I think most departments would put so much pressure on an employee if he or she did not pay her dues and make life miserable for them that they would end up paying their dues. And I've spoken to employees, and that is a reality. That happens.
Yeah, peer pressure is real. Peer pressure is very real. The fire departments in St. Louis County, for example, their market penetration with regard to, quote, voluntary union dues participation is about 99%. So go figure. Sorry, you pick.
Yes. Well, and that's one of the problems why it's so inefficient to have these agreements. And I'll give you an example. Recently, we represented a client, and an employee was caught sending impermissible text messages to a 13-year-old. And so, right away, termination. But guess what? They're represented by a union, and what's something that should have occurred in a day or 2 days ended up being drawn out for several months.
Obvious reasons for the financial disclosure is for the benefit of the employees. Here is an entire group of employees that don't have, in the public sector, even close to the same rights that employees in the private sector have. There's no reason they shouldn't have equal rights in terms of knowing where the dollars come in or knowing where the dollars go out for the union that's taking their dollars and using their dollars without telling them where it goes and how. That's really the primary benefit, is to have that disclosure for and on behalf of and to the benefit of the employee.
So the private sector has those
Absolutely.
private sector unions?
Yes.
Okay.
And we're down to it last minute. Well, the crunch point occurs when something similar to the Chesterfield Fire Protection District occurred, and the taxpayers simply say enough is enough. And enough people show up at the polls and vote out the group that had been elected through special interests. And we still have the power of the ballot, we still have the power of the vote. And to that extent, the people can take it back if they so choose, if they make an effort. But it's got to be education, and it's got to be the effort.
And I would argue, the crunch point has already come because they keep raising your taxes. I mean, they do it incrementally where, over a period of time, they're making up the differences through the taxpayers' money. And, you look through a 10, 20-year period of time, it's a big difference.
The frog in the pan.
So, before they close down the municipality, they're going to just raise your taxes.
And you did see one municipality that shut down. Clarkson Valley is now going to merge into Chesterfield. So they're giving up the ghost. They had so few people participate in their election that they just notified Chesterfield that they're giving it up and throwing their hat in.
Thank you, Brian. Thank you, Jim.
Thank you.